Hello and welcome viewers, you're watching In Depth with your host Kriti Mishra. A government normally functions by dividing its work between its organs, with each organ performing some specific function. It primarily performs three main functions: making of laws, enforcing the laws and adjudicating disputes. In this edition, we'll focus on the three organs of the government and their functions. We will also try and understand the relationship between these organs. Come along. As a community of persons permanently occupying a definitive territory, legally independent of external control and possessing an organized government, which creates and administers law over all persons and groups within its jurisdiction, is called a state. Effective and efficient governance is the expectation of every civilized society. This role is performed by the government, which is one of the four essential elements of the state, along with population, sovereignty, and territory. No state is possible without a government which not only provides security to the people, but also looks after their basic needs and ensures their socio-economic development. At independence, India was not merely large and diverse, but also deeply divided. A constitution designed to keep the country together and to take it forward had necessarily to be an elaborate, carefully worked out and painstakingly drafted document. For one thing, it sought to heal the wounds of the past and the present, to make Indians of different classes, castes and communities come together in a shared political experiment. For another, it sought to nurture democratic institutions in what had been a long culture of hierarchy and deference. In one of his speeches to the Constituent Assembly, Dr. B.R. Ambedkar, while underlining the importance of constitutional morality, emphasized that the essence of constitutional morality was to regard the Constitution as supreme and to follow the constitutionally mandated procedures regardless of any ideological differences. All three organs of the state, persons gracing the constitutional posts, members of the civil society and common citizens of India are expected to abide by constitutional morality. For articulating the aspirations of the people, there are three organs of a government: the Legislature, which makes the laws; the Executive, which implements them; and the Judiciary, which interprets laws and decides disputes. The organs of the government are so structured that they can adequately perform the functions required of them. The makers of the Indian Constitution wanted to ensure that the government would be sensitive to public expectations and would be responsible and accountable. The other alternative to parliamentary executive was the presidential form of government. But the presidential executive puts much emphasis on the president as the chief executive and as source of all executive powers. There is always a danger of personality cult in presidential executive. The makers of Indian Constitution wanted a government that would have the strong executive branch, but at the same time, enough safeguards should be there to check against the personality cult. In the parliamentary form, there are many mechanisms that ensure that the executive will be accountable and controlled by the legislature or people's representatives. So the constitution adopted the parliamentary system of executive for the governments both at the national and state levels. According to this system, there is a president who is the formal head of the state of India, and the prime minister and the council of ministers which run the government at the national level. At the state level, the executive comprises the governor and the chief minister and council of ministers. The Constitution of India vests the executive power of the Union formally in the President. In reality, the President exercises these powers through the Council of Ministers headed by the Prime Minister. In this formal sense, the President has wide-ranging executive, legislative, judicial and emergency powers. In a parliamentary system, these powers are in reality used by the President only on the advice of the Council of Ministers. The Prime Minister and the Council of Ministers have support of the majority in the Lok Sabha, and they are the real executive. Before the 91st Amendment Act of 2003, the size of the Council of Ministers was determined according to exigencies of time and requirements of the situation. But this led to a very large size of Council of Ministers. Besides, when no party had a clear majority, there was a temptation to win over the support of the members of the Parliament by giving them ministerial positions, as there was no restriction on the number of the members of the Council of Ministers. This was happening in many states also. Therefore, an amendment was made that the Council of Ministers shall not exceed 15% of total number of members of the House of the People. The Prime Minister acts as a link between the Council of Ministers on one hand and the President as well as the Parliament on the other. It is also the constitutional obligation of the Prime Minister to communicate to the President all decisions of the Council of Ministers relating to the administration of the affairs of the Union and proposals for legislation. Meanwhile, the Vice President, elected for 5 years, is also the part of the executive. His election method is similar to that of President. The only difference is that the members of state legislatures are not the part of the Electoral College. The Vice President acts as the ex officio chairman of the Rajya Sabha and takes over the office of the President when there is a vacancy or otherwise. The Vice President also acts as the President only until a new President is elected. Besides political executive, we also have permanent executive. The permanent executive, that is, the bureaucracy, is involved at every stage of the decision-making process and maintains continuity in administration. Often, the political executive depends on the bureaucrats because of their technical expertise and knowledge. The opening and last sentences of the preamble, "We, the people, adopt, enact and give to ourselves this Constitution," signifies the power is ultimately vested in the hands of the people. Parliament is the supreme legislative body of India which reflects the will of the people. Parliament is the supreme legislative body and a living epitome of freedom and sovereignty of the people of India. It occupies a preeminent and pivotal position in India's democratic polity. The distribution of powers between the Union and the states followed in the Constitution emphasizes in many ways the general predominance of Parliament in the legislative field. Apart from a wide range of subjects, even in normal times, the Parliament can, under certain circumstances, assume legislative power with respect to a subject falling within the sphere exclusively reserved for the states. The Parliament is also vested with powers to impeach the President and to remove the judges of Supreme Court and High Courts, the Chief Election Commissioner and Comptroller and Auditor General in accordance with the procedure laid down in the Constitution. Legislature of the Union, which is called Parliament, consists of the President and two houses known as the Council of States or the Rajya Sabha and the House of People or the Lok Sabha. Each of the two houses of Parliament has different bases of representation. The Rajya Sabha represents the states of India. It is an indirectly elected body. Residents of the state elect members to the State Legislative Assembly, and the elected members of these assemblies, in turn, elect the members of the Rajya Sabha. The Lok Sabha and the State Legislative Assemblies are directly elected by the people. For the purpose of election, the entire country is divided into territorial constituencies of roughly equal population. One representative is elected from each constituency through universal adult franchise, where the value of vote of every individual would be equal to another. At present, there are 543 constituencies. This number has not changed since 1971 census for the Lok Sabha. In any society, disputes are bound to arise between individuals, between groups, and between individuals or groups and government. All such disputes must be settled by an independent body in accordance with the principle of rule of law. The judges may be nominated by the head of the state or appointed by following a process of selection or elected or co-opted by fellow judges across the world. In India, judges are appointed through collegium system. It is a system of appointment and transfer of judges that has evolved through judgments of the Supreme Court and not by an act of Parliament or by a provision of the Constitution. The Constitution of India provides for a single integrated judicial system. The structure of the judiciary in India is pyramidal, with the Supreme Court at the top, high courts below them, and district and subordinate courts at the lowest level. The lower courts function under the direct superintendence of the higher courts. The first and the foremost function of the courts is the administration of justice. The courts hear and decide cases of all civil, criminal, and constitutional nature. In countries having written constitutions, the courts are also entrusted with the power of interpreting the constitution.
The Constitution lays down the structure and defines and delimits and demarcates the role and functions of every organ of the state, including the judiciary, and establishes norms for their interpersonal relationships, checks and balances.
The legislative branch is responsible for enacting the laws of the state and appropriating the money necessary to operate the government. The executive branch is responsible for implementing and administering the public policy enacted and funded by the legislative branch. The judicial branch is responsible for interpreting the Constitution and laws and applying their interpretations to controversies or disputes brought before it. The Constitution of India embraces the idea of separation of powers in an implied manner, despite there being no expressive provision recognizing the doctrine of separation of powers in its absolute form. The Constitution does make the provisions for a reasonable separation of functions and powers between the three organs of the government. Constitutional provisions ensuring separation of power are Article 50, which says that state shall take steps to separate the judiciary from the executive. Articles 121 and 211, which says that judicial conduct of a judge of the Supreme Court at the High Courts cannot be discussed in Parliament and the state legislature. Articles 122 and 212, which says that validity of proceedings in Parliament and the legislatures cannot be called into question in any court. Article 361, which says that President or the Governor shall not be answerable to any court for the exercise and performance of the powers and duties of his office.
संविधान में जो मर्यादा दी है उस मर्यादा का पालन न्यायपालिका भी करे। न्यायपालिका से भी अपेक्षा की जाती है कि जो उनको संवैधानिक मैंडेट दिया गया है वो उस मैंडेट का उपयोग करे, लेकिन अपनी प्रत्यक्ष शक्तियों के प्रथनकरण और संतुलन को के सिद्धांतों को बनाने में भी सहयोग करे। ये अपेक्षा हमारे पीठासीन अधिकारियों की है और इसीलिए विधायिका, कार्यपालिका, न्यायपालिका को संविधान ने शक्तियां दी है, क्षेत्राधिकार दिया है और उन क्षेत्राधिकारों में रहकर हम किस तरीके से और जनता का भरोसा, विश्वास जीत सकते हैं, इसके लिए हमें काम करने की आवश्यकता है।
The governance of any country requires the making of laws, their execution and interpretation, which is carried out by the legislature, executive and the judiciary respectively. Thus, all organs of government have their own assigned roles and at the same time they are also linked to each other. It is upon their harmonious functioning that a political system acquires stability as well as vitality.
The doctrine of separation of powers seeks to protect the centralization of power in one hand. The application of this principle makes the government liable, accountable and answerable to its citizens for its actions, thereby aiding in the promotion and protection of human rights. Well viewers, that's all we had for you in this edition. Thanks for watching and stay tuned to Sansad TV.
To watch more programs of Sansad TV, subscribe to our YouTube channel and don't forget to like and share them.